Video 3 of 3, quickly listing some of the bigger changes that are impacting us as a result of the arrival of the new GDPR legislation. In terms of data breaches, and this could come in all sorts of guises, it might be the data being released into the wild because of hackers or some sort of security breach, but it equally might be that you've accidentally deleted data that you actually need to be able to continue looking after somebody. So depending on your perspective on that particular relationship with the data subject, it's not just about having your data hacked or the firewall left open or something. However, that is certainly the most common issue that we're hearing about in the media and hearing about from the experts in places like the ICO these days. You have a duty now under GDPR to make all sorts of efforts to prevent personal data breaches. I don't just mean all sorts of efforts, it actually defines it as appropriate organisational and technological measures. So yes, technologically you need to have the right firewalls, you need to have antivirus tools, you need to have the operating system patched to make sure any vulnerabilities are currently and up to date. But you also need to have the organisational measures, and so that will be training for your staff, it might be physical security to your building, laptop encryption, things like that. So there's all sorts of areas you might need to consider to make sure that you're living up to the proper duty you have to prevent personal data breaches. They might still happen. In fact, it's interesting, of course, that some of the biggest and the best names are finding that they are prone to those things. So they might still happen, but therefore you have to be making efforts to detect it. So you need to be trying to find out if there is a breach or when a breach has happened as soon as possible. And the reason you need to do that is so you can fulfill one of the other key requirements of the GDPR, which is to notify people of a breach, most especially if there is a risk to their rights or freedoms. In the immediacy, that might mean that they're at risk of fraud or something like that. It might also be the case that even if there is no risk to the private individuals to any significant extent anyway, you're still obliged to inform the relevant authority in the UK, that's the ICO. And they occasionally then might use your own information to smack your wrist with a large fine, but that's part and parcel of the way the system's meant to work. In an effort to try and make sure that there is nobody just sidestepping this completely, the regulations about processors and controllers have been tightened up quite a long way. In the past it was possible to basically outsource your headache to other people, and if something went wrong you could just lay the blame off on them and say, no, we asked this people to do this for us. That's not really the case anymore. As the data controller, you have a need to have properly checked into the processes to make sure they're an appropriate place to be doing it and that their systems and their procedures are acceptable. And in fact, you now have joint liability, the processor and the controller, for anything that may go wrong and any of the impact or fines that there may be as a result of that. So what this actually means is that yes, you need to do your due diligence on any processors you ask to do work for you, and you should definitely document that to show that you cared and took proper efforts to do so, but in fact they need to do the same for you. They need to check that the data that you're using is appropriate, legally gathered and so forth, or else they might be inadvertently committing something which is a breach of the GDPR in their own sense. So I think you can expect that if you're using processors that they will be checking into you as much as you need to check into them, and at the end of it, any arrangement you do have has to be governed by a written contract. And it's quite important and very explicit in GDPR. It must be a written contract so there's no ambiguity about who was doing what, and therefore the blame can't be passed around. There is going to be somebody responsible and somebody accountable, and that's probably you, so make sure you get it right. One of the other things is the burden of proof has changed. It's now moved in such a way that effectively you're guilty until proven innocent. The GDPR specifically says you must be able to demonstrate that you're in no way responsible for the bad thing that's happened with the data. That means that your record keeping really does need to be up to date and up together. So even though you might be making very well informed and advised decisions, you should be trying to write down why and what those decisions were and what the factors were you took into account. Because it might be important one day when you're standing in front of a judge trying to explain that in fact you really did go through all the detail you could, but somebody misled you in a way you couldn't possibly have discovered. So it's important to make sure those notes are together as well, but also you do have to be able to prove that you're in no way responsible. So it's important that you're not just talking about the notes, you're talking about the decisions, and the thinking behind those things as well has been done with the right intentions. because all of this has been underlined by a much easier, that's the plan anyway, much easier and much stronger enforcement action. There is already much discussed massive fines of 4% of your global turnover, or 20 million euros, which can be levied for a bad data breach, whichever is the greater, which is quite a significant, interesting thing. A 20 million euro fine would be catastrophic for many people. In addition to that, specifically and explicitly, it has opened up the opportunity for class actions, which can, of course, become quite significant bills. And certainly a number of, here in the UK, a number of legal companies are already gearing up to be able to promote those, recruit the cases, and then act on their behalf, rather like the PPI claims recently. There's also scope for personal damages, so the person whose data has been breached can now claim damages for the material damage that's affected them, so the loss of money or property, but equally for non-material damage. So that might be that they feel sad about the fact that their data is in the public domain, or humiliated, and then it will be down to a judge to define an appropriate penalty and an appropriate damage to recompense that. So there's huge administrative fines, there's class actions, and there's now personal damages, so people actually stand to benefit, if they choose to, by bringing in action. It definitely does pay to have thought it through and to keep the records in advance. Those are just some of the changes that the new GDPR legislation is bringing on stream. It's important that you keep your eye on the detail, though, because specifically for you in your organisation, you may have some specific nuances which are also changed. The ones I've just discussed there are sort of the top line news, but there are others. Anyway, that's it for now. Look forward to seeing you again.